The day before
Yeah.
yesterday matter was
Who has done it?
this matter. I appeared for the UGC, my lord.
Hey,
My lord, remember.
who mentioned it in?
Addition of party was allowed. And
He calls me.
but Mr.
You appeared on behalf of?
UG University Grant Commission. My lord directed to serve copy immediately on that day. Accordingly, I have served.
Yes.
My lord, may I have a lordships kindly, my lord, to mention for inclusion, my lord, two analogous assigned matter, my lord. My lord, one, my lord, Group 9 Police in Action of 2019. And my lord, there is a my lord, assignment order passed by Honorable Chief Justice that my lord, one Group 5 matter will be heard on Group 9 matter. My lord, I have enclosed necessary orders.
Assignment.
Mention, but this is a pension.
Assignment.
Pensionary benefit matter, but my enhanced fixation of pension has been withheld due to overdue after return. It cannot be done in terms of the Rafiq Moses case. So, my lord, that has not been done. So, my lord, I have
For pension matter. You have missed the bus. What can be done? It was called on, but at that time you are not present. No, give the other person also the opportunity to place their case. Your matter, so some matters will be called or taken up again and again. Again and again, but others matter will be left unattended. But it cannot be. You mention when you will get your chance, then it will be taken up. What can be? To be mentioned.
My lord.
Okay.
Lordship, may I mention this matter for inclusion in the list? Your Lordship,
Why?
It's an educational matter. Herein, the writ petitioner has not been the superannuation benefits has not been given.
Which benefit?
Your Lordship, I am for the writ petition in this matter.
Which benefit?
Superannuation benefits, Your Lordship. Your
Why?
Lordship has jurisdiction.
Why?
Your Lordship, she's in her
Why such benefit has not been granted to him?
handed to her. Your Lordship, as far as she was discharged from her service back in
Dismissed
she
from
was
service.
dismissed from her service.
Okay, wait for some time.
My lord, may I have your lordship's kind leave, my lord, to mention a pension matter, my lord. The petitioner before your lordship is a 67-year-old widow, my lord. She is the wife of an assistant teacher, my lord, who had deceased, my lord. My lord, the department has denied her right to pension, my lord, despite an order, my lord, which allowing her part of the pension to be given, my lord. Two things are happening. One, she is not getting her part of the pension, my lord. A meager amount of 2,005.
Two wives.
Three wives. The two wives died, my lord. She is the only surviving wife today, my lord. He belongs to a Muslim community, my lord. All the three wives' names are there in the PPO, my lord. I'm so grateful.
Pension matter.
I'm so grateful.
Matter, my lord. This is relating to pension matter. My lord, petitioner retired on 30th of November 2023 from the headmaster post. My lord, after retirement, Lordship School Authority raised an objection to the board DI that during his service tenure, one transfer has been made by him. That's why he demanded money. That's why objection. Ultimately, no objection has been issued. But till now, 2 years already been gone. No retirement benefit, nothing has been given.
One of pension matter.
Non-prosecution, 2018 Group 9.
Non-prosecution to be mentioned. Okay, call the list.
Your Lordship.
You take instruction, then come.
Matter number 1, I am for the petitioner.
Yes.
They served on 29th the affidavit in opposition. But only yesterday I prepared and by one day, and I served them with the affidavit in reply. Only it's a very interesting case, my lord. A man who was appointed as a
Petition may be taken on that.
এসছে ওইটা করে দাও না ভাইটা একটু বলার পরে
কোনটা?
যেরকম বলেছে এখনো চেষ্টা করি পারো।
এটাই ওটা?
হ্যাঁ ওইটাই সেটা, ওইটাই সেটা। My lord, may I?
I beg to appear on behalf of the respondent number 7, my lord. Due to my ill health, I am appearing virtually, my lord.
Private respondent. My lord, the petition.
Where is that memo, 6th April memo?
My lord, I am coming, my lord. It is hearing, my lord. Kindly allow me to place my case according to my reading, my lord. I am
Oh, it is a long order.
all its, my lord,
100 bar.
information.
It is in order.
No, it may be reason order, my lord. I am coming. How the reason order passed, I am coming. If it is a reason order, then it cannot be challenged. It is not the case. My lord, kindly turn to page 33. 33 first. 33. Several orders passed in my favor. I shall show your lordship. How did principal say pass that order? 33 is the notification
Yes.
for appointment of para teachers. I'm reading for your lordship. রাজ্য প্রকল্প দপ্তর সর্বশিক্ষা অভিযান নির্দেশ ও সর্বশিক্ষা অভিযান নদিয়া জেলা কমিটি সিদ্ধান্ত অনুযায়ী, নদিয়া জেলা কমিটির সিদ্ধান্ত অনুযায়ী এই জেলার প্রাথমিক ও উচ্চ প্রাথমিক বিদ্যালয়ে 4000 জন পার্শ্ব টিচার বা শিক্ষক শিক্ষিকা নিয়োগ করা হবে। প্রারম্ভিকভাবে প্রাথমিকে 1300 and উচ্চ প্রাথমিকে 2200 এর কিছু অধিক পার্শ্ব শিক্ষক চুক্তির ভিত্তিতে নিয়োগ করা হবে। ব্যক্তি বাকিদের প্রয়োজন ভিত্তিক নিয়োগ করা হবে। আগামী 29 June 2004 to 7 July 2004 অবধি সাদা কাগজে দরখাস্ত জমা দিতে হবে। প্রাথমিক ক্ষেত্রে সংশ্লিষ্ট বিদ্যালয় পরিদর্শক অফিসে, উচ্চ মাধ্যমিক ক্ষেত্রে সংশ্লিষ্ট স্কুলের ম্যানেজমেন্টের কাছে দরখাস্ত করা হবে। নাও দিস ইজ ভেরি ভাইটাল। সমগ্র নিয়োগের ক্ষেত্রে 50% মহিলা হবে। সমগ্র means 4000 teachers, so 2000 should be female and 2000 to be male, and they should be appointed in different schools. This whole district 50-50 that has been upheld by this court by an order in my case. I shall coming to your lordship.
খানিকক্ষণ বলবো তো?
হ্যাঁ খানিকক্ষণ বলবো।
My learned friend might take some time. May I take a short leave?
Yes. My lord, then come to page 35. 35, I applied for the post and letter of engagement of an additional petition in my favor of my client, that is Rafiqul Alam Biswas. Stop. He is the petitioner before lordship. He was appointed as per and an agreement was executed on 31st October 2006. My lord, kindly turn to once page 67. Then I'm coming. Why 67? It will help me. Only turn page 67. Yes. My lord, page 67. My lord, kindly, it was annexed in this way. My lord, 28 September 2006. This is the recommendation of the জেলা অধিকারীকরণ এবং সর্বশিক্ষা অভিযান নদিয়া ডিস্ট্রিক্ট ম্যাজিস্ট্রেট। He is giving my name by left hand side, Rafiqul Alam Biswas. This is my appointment approved recommendation of the district committee by the district magistrate. Well, kindly see last line from this, বিশেষ দ্রষ্টব্য অনুমোদন দেবার সময় জেলাগতভাবে ডিস্ট্রিক্ট ওয়াইজ, which is the case of mine, জেলাগতভাবে 50% মহিলা প্রার্থী হিসাবে মধ্যে রাখা আছে। His appointment within the 50% of district, he was given, who is saying, district magistrate is saying. So from 2006, I was allowed to continue. I am getting honorarium. In the meantime, very peculiar case made out by the private respondent. Kindly come turn to page. I have annexed the writ petition because I was not party by obtaining certified copy, page 37. By obtaining certified copy as well as the order. It is the foundation of entry in the service of private respondent. How he misled the Honorable High Court, kindly see. By the influence of the party members, he got the order otherwise. He taken the order otherwise. Page 37, my lord, kindly see page 39. 39.
Yes, you are not party, yes.
Not only party.
Uh,
Dilruba Khatun, the petitioner. He is the private respondent here.
hmm,
He has snatched my appointment by his influence.
hmm,
Page 39, who is the petitioner? Dilruba Khatun.
hmm,
He is the private respondent, 7 before your lordship.
hmm.
Although he made an application before the court by making a representation that he should be considered. My representation is as page, peculiar case. My representation is at page 61.
Yes.
Why he said it was moved? শূন্য পদে প্যানেলভুক্ত পার্শ্ব শিক্ষক নিয়োগের জন্য আবেদন।
Hmm.
অভিনয় বিনীত নিবেদন এই যে আমি করিমপুর টু বাসিন্দা হইতেছি, বৈরাদহ টু গ্রাম পঞ্চায়েতের স্থায়ী বাসিন্দা। বলো কাইন্ডলি মার্কেট বৈরাদহ।
Hmm.
গত 6/9/2000 তারিখে বৈরাদহ ইউনিয়ন হাই স্কুলে পার্শ্ব শিক্ষকের জন্য আবেদন করি। বৈরাদহ ইজ নট মাই স্কুল, মাই স্কুল ইজ দোরাদহ ইউনিয়ন হাই স্কুল। মাই স্কুল ইজ দোরাদহ ইউনিয়ন হাই স্কুল।
Dorado.
এই যে এটা একটু দেবেন তো। I'm giving the true name of the school for your lordship's convenience. This is the two schools. My lord, he made an application, or his representation is called
Yes.
but his representation is
In his from his representation, former representation, it is appearing he applied for the post of para teacher in Boiradaho
high school.
High School.
Right, well, I'm grateful to your lordship.
Boiradaho
Boiradaho
Union High School. Yes,
Dorado. I have given names of the school at a,
yes, yes. Doradaho is a separate school.
yes. What was the order passed by the school? Kindly see. What was the order passed by the school? By this order, the authority granted him teacher. Kindly see.
Now, what order was passed by the court? Yes.
Page 66. My lord, affidavit of service filed today by the respondent be kept on record. The petitioner filed this petition with a prayer for direction upon the respondent number 2, district project officer, to take necessary steps for appointment of additional para teacher in Boiradaho Indian High School. Court mentioned that Boiradaho, I am Doradaho. Two names I have given you, lordship. Boiradaho Indian High School, Boiradaho district Nadia. A representation of the petitioner represented by the respondent number 2 on September 20, 20. In view of that, I direct the respondent number 2 to consider and dispose of the approach representation of the petitioner in accordance with law for a period of 4 weeks. My lord, I am working since 2006.
Okay, but you are saying that your name was recommended for Doradaho Union High School.
Not only
But,
recommended, I
but-
have appointed.
Page 67, page 67.
Page 67 is Doradaho Indian High School.
Eh?
He is Boiradaho. Two schools, and one is Doradaho, one is Union. Mine is Doradaho. Top Doradaho Union High School recommendation. Page 67. So, my lord, this order was passed. No, you should be astonished how the authority acted upon. This order was passed 18/12/2006 within 4 weeks. That means 18 January 27, it should have been disposed of, at least. What they did, my lord, kindly see page 68. Kindly see, my lord, kindly follow up what I am submitting, kindly verify. Page 68.
No, you are also Boiradaho. It will be.
Doradaho. I am.
But the petition which was filed by the Dilruba,
He is paying for.
he made party to the headmaster Boiradaho.
No.
Boiradaho.
Boiradaho and Dhoradaho is the same institution.
Same.
Yes, he is creating this confusion since 2006. Today we are in 2024.
Coming.
This is the fourth writ application.
My
This is
lord,
not the first one, this is the fourth writ application. The same thing is going down.
kindly
The
allow me.
Secretary Education Department.
Okay, let him complete.
I shall complete. My lord, page 68, a certificate is given by the headmaster of the school, that is Doradaho. There the last page, at present 17 posts of para teachers, 16 para teachers working in the school, 16 para teachers out of 16 para teachers, 6 male and 10 female. So school-wise, not at all. If that is the school-wise, then those figures should be same. But 10 and 6 and 10. Then come to very important, my lord, page 69. How the authority acted upon by this order. My lord, kindly see top. Proceeding compliance of the order passed in case number Dilruba Khatun versus Sheikh. That is the order passed by Justice Devashish Korgupta, which your lordship, I read before your lordship in Doradaho. My lord, petitioner appeared before at 1 p.m. Perused the document of the petitioner. The merit list of the male and female candidates duly attested by the Secretary Managing Committee, Headmaster of Doradaho Union High School. Doradaho, no, Union High School is my school. It also brought to my notice that a government order, no appointment by memo number such and such dated 27th March 2010, issued by State Project Director, where it is mentioned that no further teacher will be engaged in upper primary teacher. So this is a ban.
Okay, he constitute a committee. He constitute a committee.
No. This is the order. He is saying this is a circular. This is a ban regarding appointment of para teacher from this up to issuance of this circular. She was appointed in 2011. In this situation, the prayer of the petitioner, Dilruba Khatun, cannot be considered pursuant to the order of Justice Devashish Korgupta, as is also then one. Kindly consider. Who passed this order? District Project Officer, who has been given direction. So Dilruba Khatun cannot be considered. However, he pays. However, an inquiry into the alleged illegal appointment of somebody instead of petitioner will be conducted. Somebody means I was appointed. As DPO of the only recommending authority and the managing committee of the school is the appointing authority, at present issuance of number 27th March 2007, I have annexed. He is a ban regarding appointment from June 2010. Approval of Paschim Banga Shiksha Board is required before issue of recommendation. In such case, DPO has no direct role on the issue to engage a letter of the petitioner. He has no role to engage any person by the same circular. Then, my lord, kindly see next page. What they have said. Same officer, without following an earlier order, without making any inquiry, passed an order in compliance of the order of the Honorable High Court dated Dilruba Khatun, that is 25569 is that matter which Dilruba moved of 2006. When this order was passed, 11/7/2011. Kindly see the date. Court directed to hear within 4 weeks. When they are considering after 4 and 5, 4 years, 6 months, they are all on a sudden passed the order. Dilruba Khatun set up with others. He is hereby informed that Honorable Justice Devashish Korgupta has been pleased to kindly dispose of the requisition by directly disposal to consider the case and dispose the representation submitted by him. Which representation? Boiradho. Kindly see. Boiradho is constituted. The Honorable Justice Devashish Korgupta, as is also recorded Boiradho. Also recorded. There is no modification prepared. There is no recalling of the order. Nothing else. So, as if court directed in Doradaho school, where I am appointed. After due hearing all parties, it is relevant that the claim of Dilruba Khatun is justified. Why justified did not disclose. Hold on, 11. The engagement of Dilruba Khatun therefore stands approved. Kindly see how a cryptic order was passed. So earlier, same officer passed that his case cannot be considered. Same officer, by the same order of the court. You are requested to engage Dilruba Khatun, who you means college managing committee as a para teacher within 7 days from the communication of the order. So contradictory order was passed by the authority. One is his case should not be considered. One, he is to be considered, he is to be appointed. When after 4.5 years, without modification, without recalling of the order passed by this Devashish Court. My lord, then, my lord, I have challenged this order. Next page, page 71. This is very important. Passed by Justice I.P. Mukherjee. There is also here, but kindly see. Page 71, 4/7/2013. On the petition filed by the respondent number 6, that is my, that means Dilruba Khatun, here also mentioned this court directed the respondent to, in that it was to consider and dispose of the representation of the petitioner in accordance with law within a period of 4 weeks from the communication of the order. Justice I.P. Mukherjee also recorded that 4 weeks from 2000, when the order was passed. Order was passed.
Yes, determination was made after about 5 years.
2006. Order was passed in 2006. Then the determination was made after about 5 years, from 29 June 2009 to 11. This is the order of the district court officer recorded by this court. Then, if you want, I have read the order. The copy of the order shall not send to the Paschim Banga Shiksha Commission for information. Not sent. There is one gross mistake that the district budget officer has committed wrong in this order. Without any reason, he has stated that the post was reserved for women. On 11, after 5 years, women. In fact, the advertisement dated 10 June 2004, that which I have read for you also from the very beginning. 10 June 2004, in the application, only 50% of the vacancy was said to be reserved for women. 50% of the vacancies. That means 4,000 vacancies. So it is divided by 50, 2,000 different schools male, 2,000 different schools female. That is the publication of notice in advertisement, and that is recorded by his lordship and accepted that. That 50% was said to be reserved for women, not school-wise. At least he should have decided the point, because the decision was crucial for the decision in point number 2, that means here, Dilruba Khatun has attended that so his claim should be accepted. That is decision in point number 2 decided immediately thereafter. On the other hand, the petition here he was working as a para teacher from 2006, when ban was not came into force. So my appointment was before the ban, 2009. And I continued up to 2011. And without giving any notice to me, she was appointed, and I was terminated. When the decision of the project officer dated 20th June was met, then kind recorded. I think for the ends of justice, it will be subserved if the project officer revises his order dated 29 June 2011 within a period of 3 months from the communication of the order, on the basis of the observation made thereof, order accordingly. No appeal, nothing. Till final decision is made by the district project officer on the basis of this observation above, the petitioner who was displaced by the order of 29 June 2011 will also permitted to work as a special case along with the respondent, he's been private respondent in that case. So I was directed to be allowed and continue, so that there is fairness in the whole process. This court observation. The above decision will be released in order upon hearing the petitioner and the respondent. In that case is Dilruba Khatun. Here is respondent 7. The petitioner will be paid honorarium. My client will be paid honorarium from this date till the date of decision. If the petitioner succeeds in the decision, that is my client, he will be paid honorarium for this entire period for which he has been working since 2006. But these observations practically, they are so much aggrieved that I am to pay so much money. If this order was not passed, most probably I should have been given the appointment. If this order is allowed, then I should be paid entire salary. This is the court observation. To maintain parity in the respondent number 6 should also be paid in terms of the actual stipulation. I know that the appointment is a contractual appointment and no change of permanent. Permanent code should not be disturbed because the para teacher contractual appointment. So this order was passed. Well, kindly see next page.
Yes,
Who tried to accommodate me, but I was not allowed to join. I was not paid any honorarium by the order of this court. And I am reading for your lordship. He is to certify that Rafiqul Alam Biswas, that is my client, son of such and such, of village such and such, Sinodia, had been serving as a para teacher as per engagement letters by the Nodia, memo number 28/9/2006. Since the date of joining,
okay, he has been working, yes.
I wish re-engagement in the post for the interest of justice. So as per court order, the school also saying that we wish that he should be re-engaged. Well, the order which was passed earlier, again another order on 29/6/2011 in different language. Language post is reserved for women. First post that is called, that is recorded by Justice I.P. Mukherjee, that there was a gross mistake by saying that the post is for women. Court said, I revise your order. But this is that order which your Lord, which Justice I.P. Mukherjee considered.
Yes,
Then I.P. Mukherjee order was considered how? Page 76.
yes.
In compliance with the order passed by the Honorable Justice I.P. Mukherjee, dated 4/7/13, in respect of document number such and such, the undersigned took the matter for hearing. But in the meantime, I was not allowed to join. Though his lordship directed that he should also be allowed, he should be paid honorarium. Nothing. Persons who were present at the hearing
Such and such, yes.
has come to the knowledge of the undersigned. District Court officer is saying, I am hearing that respondent was 7. There were 7 vacancies in Dorado. So Boiradaho is not coming. Boiradaho gone. Boiradaho is the order passed by Justice Korgupta. Boiradaho is the application made by that lady. But now Boiradaho gone. Now she is coming in Dorado. This is peculiar. Why Dorado? Nothing disclosed in the order. Why she is in Dorado? Her claim was not Dorado, and order was passed in terms of that order, Justice Devashish Korgupta, which recorded that he made application for Dorado. Even vacancy Dorado Union High School, for which a panel was sent to the school from this end, considering 4 female candidates and 3 non-female candidates. They are 4 and 3 appointed. After resignation of Susmita Mondol, they are making a story which is Susmita Mondol, I am not interested. Susmita Mondol, after resignation of Susmita Mondol, was get appointment in the school in the year 2006. But in my appointment, in the letter, nothing was mentioned that in place of Susmita Mondol. From the time the continued service till the concept, that is up to 2011. His engagement was by memo number 11. In respect of the order passed by Justice by Dilruba Khatun. Well, how the order of Dilruba Khatun 2559/2006 is taking in her favor. How? I don't know. How they are saying that Dilruba Khatun's order in 2006, it is her favor. Her favor for conscience in another school. In compliance with the order date with such and such, another date of hearing has been fixed. That also is recorded. Skip over that. During hearing,
So it is the district project officer says that the post was reserved for women. And initially one Susmita Mondol appointed in that post.
resign.
Susmita Sen resigned. So that Susmita Sen resigned, that post is reserved for women.
Yes.
That means one woman candidate should be
No, I'm coming.
inducted.
Women candidate means someone, woman is passing in the door, in the door, and he should be catched. Yes, he should be appointed here. That is the observation made by this court in different time. I'm coming. That if it is at all reserved, then it should be followed by recruitment rules, not bringing someone. Because there is no court order that she should be replaced by she should be replaced where I am working. That is not the case. I am coming. Each and every time said that the vacancy due to regional Susmita Mandal should be appointed someone by following the recruitment rules. That I am coming. So his appointment was illegal. That is also observed by the State School Education Department. Her appointment also illegal. That is recording of the principal secretary. I am coming to that. So my lord, he is saying that.
Okay, where is the principal secretary says that I mean, no, you take me to that.
No, I shall not.
Eh?
My lord, before that one, I shall leave.
No.
I think allow.
Oh no, you don't take so much of time. Any matter.
Out of this court. My lord,
Any matter, whether you will take an entire day.
no,
You show the principal secretary says.
That another order was passed. That should be read by your lordship. What he has said. So he has been given appointment by saying that 50% even school-wise. He is saying school-wise, can he record? Page 77, there is a dispute. Page 77, kindly one see. Page 77.
Okay, school-wise. The word school-wise has used.
My case is district-wise. Well, then kindly see on the order at page 84. It will be clear.
It is interlocutory order.
Page 84.
Ultimately, what is the final order?
84. No, 84 is a very peculiar order. Very favor in my favor. Epidemic of 5 such, kindly see, I am reading. The writ petitioner pertains to a
Final order at page 94.
You don't read the entire order. You just what was held by his lordship.
My lord, his lordship. My lord, he should not interrupt. Well, he should not interrupt. Then I shall stop. No, he should maintain the record. I am fresh. Page, my lord, kindly should page running to page 85. What his lordship observed. May I read for your lordship page 85? The writ petitioner here is.
You come to page 94. 94 is the ultimate order.
85C, first of all, 85C, how the.
All those order has been merged with the final order.
How he passed that order? That is my challenge. When this court is saying otherwise, he will pass any order.
Interlocutory order.
This order, I want, kindly give me time, page 85. 85. Page 85, kindly see, then I shall go to the page 85.
Okay.
Second paragraph.
Go on reading.
The petitioner here claims to have been appointed in another school, namely Doragaon Union High School. He was a teacher there for my client for 5 years. Suddenly on 11 July 2001, his employment was terminated and in place 5/7 was engaged. That is Diluba. The writ petitioner filed this petition, which was disposed of by coordinate bench, that is I.B. Mukherjee. By observing there is a gross mistake that the district magistrate has committed wrong in this order. Without any reasons, he has stated that the post was reserved for women. In fact, the advertisement dated 10th June 2004 invited application of 50% of the vacancy was said to be reserved for women. Then skip over. Lordship is not giving so much time. My lord, page 86. During hearing, it was come to the knowledge of the undersigned that as per reservation policy of district SSM, 50% posts were reserved for women, and to achieve 50% reservation target, school-wise 50% reservation policy was followed. That is their case. So after resignation of Srimati Mandal, again were officers in the said vacant position is erroneous and might have been done inadvertently. They are saying that among 7 posts of para teachers in Doragaon Union School, 4 posts were reserved for women. As per vacancy statement, the district project the same policy for the women 50%. That as per reservation policy, vacant post against reservation of Susmita Mandal should have been advertised as per post reserved for women. Should have been advertised, not direct appointment. That in compliance with the said order, justice hearing had been conducted and the chamber of the other side, and after hearing the parties all concerned, all the related papers undersigned was in the opinion that the said post vacated as a result of the resignation of Susmita Mondol should have been reserved for women, and therefore engagement or occupational officer in the said school was unjustified. Accordingly, it is disposed of a supplementary evidence was affirmed on December 29, filed by the petitioner on record, page 39 of supplementary. It appears that a document dated 23rd June 2011 that was the some vacancy available in Gorawa Union School. Mr. Soibal Acharya, Rane Advocate appearing with explanation said on from his client submits that since 2011 there was involvement of any para teacher, there is at least one post out of 17 still lying vacant where respondent should Gorawa Union High School. Consequently, submits are made on behalf of the parties and also on behalf of the evidence number 7, and considering the materials of record, this court of the opinion to subserve the justice at this stage, respondent 8 shall be directed to furnish a vacancy position. What is going to whether vacancy is available to give me post service post of a teacher by way of short certification filed such and such. Then affidavit was filed. Next page 14. Affidavit was filed that vacancy is there. Pursuant to the direction, page 89. Pursuant to the direction made by this court, the respondent number 8, Sri Anindra Moiko, teacher in charge of Gorawa in my school, affirmed an affidavit on November 2002, which depicts that if there is one vacancy for the post of male para teacher, such evidence is taken on record. Mr. Soibal Acharya, Rane Advocate appearing for the on instruction submitted that if the prison is accommodated in such vacancy, the school authority has no objection. Mr. Sarwar Jahan, Rane Advocate appears to be responsible. Mr. Arjindam Chatturi appears, he played what time. Then my affidavit also I have annexed the school of the affidavit 91 and 92. And I want a judgment from your lordship in this case, how they acted. Now, my lord, the order passed to sending the matter to the direction of school, to the Secretary School Education, is page 94. Today, when the petition was taken up for consideration after hearing the submissions made on behalf of the parties and perusal of the pleadings on this report, it appears that, quote, that intervention of the Secretary School Department is necessary to solve the issue once for all. The sales secretary is already represented to learned state advocate Mr. Arindam Sinha. Next paragraph.
The matter has been referred to the secretary. Secretary Education Department.
See,
Now Secretary Education Department has passed the order, reason order.
Secretary Department was said.
What is the reason order? In reason order, what he has stated?
It is 101.
To pass the order at least 15 pages. What I am saying.
Now, what is this order? 21st March 2023?
Yes, 21st March. No, that is the order.
SPD to file the report.
Oh.
There are discrepancies of entire records were produced before the principal secretary with a report by the.
I am playing some
We
paragraph.
considered the report of the
I am placing some paragraphs for your lordship's consideration. How the principal
Kindly see
secretary.
page 9.
Then he submit
No,
or I
I
say
don't
no.
ask.
Okay. Kindly pay. Come to page 108. Come to page 108.
Allowed.
Will you go on reading the entire writ petition? The entire is all annexed.
15 pages.
You are now narrating the facts.
Only 4 paragraphs for your lordship conveyance.
You have taken you consider.
This is the goal my lord.
There are many matters.
Page 97, second paragraph.
Okay, you go on reading.
Secretary, while deciding the issue, must take into consideration which is the court's order dated 4th July 2003 passed in number such and such. There is admin and detailed order passed by this court on November 2002 that is Anindra Sinha's judgment. This is along with the order passed in proceedings. Also, affidavit filed by the respondent number 8. Affirmed that one vacancy they are disclosing vacancy position. In addition, all 3 processes the secretary shall pursue enter records of the place. So it was with the knowledge, enter fact of the enter order of this court. Kindly then come to page 98, paragraph 4. Paragraph is vital. During hearing, the petitioner submitted written submission. The report of district budget officer and state budget data was produced. In respect of the following point, the DPO report, there is a lack of clarity because who is some Dilruba Khatun and others took part in the selection process for engagement of para teacher Kerala Union High School under Koyimpur New Market
You are reading from?
on page 98.
Yes.
Order also in favor, in respect of the following members of the district project officer and Dr. Rafiqul Alam বিশ্বাস, Dilruba Khatun and others took part in the selection process for engagement of para teacher in Gorado Union School. Here is the case. His case was for others case. Gorado Union School under Koyimpur New Circle of Modia with reference to the notification number 10/6/2004. However, there is no supporting document annexed to the DQ report. Out of seven posts, 4 posts were reserved for women candidates and to maintain 50% female involvement district wise. This is the report of the district project officer who passed the order. He is saying that the advertisement of 10/6/2004, 10 June, I opened my press by saying that is not school wise, that is all vacancies 50%. Page the report also same. What he is saying before the principal secretary. So, my page 33, as read your lordship that, and I think Mukherjee also held, I think Mukherjee also held that 50% of the total vacancy. So, my lord, may I read for again, paragraph 98. Paragraph 98.
When you applied, when?
I applied before 2006. That's why I was appointed in 2006. I continued up to 2011.
You applied in 2006. That means when the advertisement was issued in 2004, then you did not participate in the selection process. Huh?
No, as per that advertisement. I was
You saw your application.
appointed.
Your appointment was given in 2006.
That is not the
Your appointment was given in 2006.
that point that he has not made the application within time of the advertisement of June 2004. That is not the case of anybody's. You're also asking, I can read. His case is not that their case is not that he applied after he had granted by 10/4/2006, 10/6/2004. That is not the case of anyone. Case is only whether the reservation will be school-wise or reservation will be district. That is whole case. That is to be decided. I think what he said, no, it is for whole. Advertisement says for whole. 4,000 posts, 2,000. That's why the report of these two authorities out of 16, 10 and 6. 6 male, 10 female. Why is the 50/50 of the school wise? So in this whole district, if we calculate, that will come 50/50 district wise. And my appointment that was recorded, which I read, that was followed. That was followed at page 67. 67. That দ্রষ্টব্য পেজ 67 once madam অনুমোদন দেবার সময় জেরাগতভাবে 50% মহিলা প্রার্থী হিসাবে মধ্যে রাখা হয়েছে। That is, they are saying, who is saying district magistrate when my recommendation was made in 2006, 28/9/2006. So my lord, জেনা দুজনকে ঢুকে ওসব গলার ধরে গেল। Can we turn to page 102? 102. Well, I am placing some paragraph of the order passed by the principal secretary. Well, page 102, paragraph 5. As per approval of the government state project director, Paschim Bongo Rajya Shikha Parishad Union by November such and such, issued guideline for engagement of additional parish and upper primary school. In paragraph 1, it has been mentioned that at least 50 of the teachers engaged have to be women teachers. That is the doubt created by the strategy. Also, how you are saying, where is your advertisement? Karabi also mentioned that the appointment authority will be district SSA committee, Sarvashika committee, who will decide which was which school has to be allotted, how many teachers, MC will be appointing authority. So out of 4,000, which school will be granted 10, which school will be granted 20, that will be decided by the DPO. Notification for engagement of para teachers, next paragraph. By advertisement dated 10/2004, respondent to resolution adopted in managing committee of 18/10/2004. It is followed in tune that the respective engagement para teacher upper primary school.
Yes, I have got. Now, what is the stand of the project officer? Okay, I have got. What is the stand of the project officer?
I'm saying
You to fulfill the 50% reservation target district wise.
Necessarily decide how many teachers will be appointed and what will be the ratio. Kindly consider.
no, what will be ratio not?
Last paragraph.
How many
Kindly
teachers?
consider last paragraph of 10.
Yes.
The resolution adopted to the. This is the following. Speaker and school-wise ratio. Kindly consider this paragraph.
This was never disclosed to anybody.
Now this was done. This is for guidance. That I can show.
This circular never seen the color of
Male and female teacher will be 50. This is one. Now you will also kindly done between 103, the second paragraph. Initially, out of 7 numbers of posts were reserved for women. It is in respect of that school. Candidates to maintain 50% women teacher reserve. 50,000 teachers was appointed on the initially on 31st of October 2006 after resignation of Timothy Shawan admitted. Then my Lord, kindly consider 103, the paragraph starts with against the recent order, Local Market Participation. Kindly consider, because my Lord has already placed this. Take 104.
yes, that I want to place.
Further, the SPT matter in the middle. Take 104. The sentence starts with further. The SPT will be the same as observed the following. There was a gross mistake in not the resolution of the district SSA committee in respect of engagement of parameters at upper primary school. Shows ratio of male and
It
female
is never
teachers
seen the color of.
twice as
It was not disclosed anywhere. It was
now
not hang
the
up.
Lordship kindly consider page 105 second paragraph.
যখন 104 করে last paragraph
Further, the norms under PSSM as mentioned number 7 March 2028 there is any parameter is the drop of the or it is
not by bringing Dilruba by advertisement, by following the rules. Other women can also apply.
Now, that is on the facts and circumstances of the case, professional conditions for the orders of the Honorable High Court passed in the instant may be said that the entire dispute and legal complication arose due to the wrong initial engagement of the petitioner in the post vacated as a result of resignation of Sushmita Mandal should have been reserved for women. Therefore, the engagement of in the seat vacancy caused due to resignation of Sushmita Mandal may not proper and justified. Moreover, as the initial resignation of was a gross mistake as it was originally reserved for women teacher and accordingly petitioners claim for it as parameter may not have any legal basis. Now, my lord, your lordship will find page 106. I'm sorry, 107. The dispute raised by the government. 107, Roman 3. In respect of dispute raised by government regarding the name of two schools, Gohirabad Indian School and Gohirabad Indian School, is observed as follows: appears from the petition affirmed by the additional district investigation officer. Kindly skip by the last two lines. In other hand, there is no other school in the same geographical area whose name is Gohirabad Indian High School.
have come
Then
to the
paragraph B.
right by a-
Further, the district inspector of schools of India has confirmed that Doragaho Junior High School, Mr. Sakan is meeting the office of the district inspector of schools of India. The DISC code of the school is Sakan and the IOS code is Sakan. Doragaho Junior School, there is no school by this name in the same geographical area in the district of India as of therefore only there is only one school. Both of them are participating in the serial selection.
Then they should have come before this court to modify.
Was wrongly appointed to watch me.
Yes,
I is
not
detailed
modified.
kindly consider page 108,
Yes.
paragraph 6. Considering the opposite facts and circumstances of the case, provision guidelines for it, the parameters in our guidance to the orders of the past in the incident case, there appears to be entire dispute and legal official investment of whichever with a post-treaty as a result of this issue. It was result of therefore the was void ab initio improper and unjustified. Subsequently, the then video is said to not comply with the order of the Honorable High Court dated Sakan that is given in and passed the result order. Even this, then even video is said by passing the order in the of the matter as appeared clearly from the report submitted by KSP. This said the headmaster of the teacher in charge or secretary of the council for
Then modify the vacancy for following recruitment rules.
district magistrate serve the district in the year 2006 and 2006 and same the report of other application action. Similarly, suitable intellectual time by 2009 may also be the same observation. I will give the now, madam, last 3 lines of paragraph B. Hence, I am unable to consider the pair of the parameter so for making the concept. Now, there are 2 issues. First is the initial appointment of the petitioner, which was already wrongly filed from the principal secretary's order that it was wrongly done. My submission is already was rectified. We have taken steps against the officers to mitigate the mistakes. Now, madam, the law should not be arbitrary. Now, your lordship will find, madam, this is an admitted fact that the vacancy as a justification of the litigation should be covered. This should have been filled up by a litigation. It was
By following
now, I said, only one document, madam, on the basis of your lordship, kindly consider one paragraph, madam, of page 102, on the basis of which, madam, the district is considered the entire issue. Page 102, the last paragraph. This has not been checked. The resolution
does not disclose to anybody.
October 2004 is the following respect of engagement of para teacher at our primary level supervised issue of teacher. This is the second issue. The first issue is illegal appointment of the teacher. Second is whether this issue should be supervised or district. Your question right here. Consider my page 12. This is the guideline.
The affidavit of opposition on behalf of on behalf. Yes. Yes, Pap. Yes. Yes.
Also, capital one our primary supervised enrollment should be ascertained about assessor class Calcutta school has we mentioned that that particular school.
It is student pupil ratio. Yeah, today, yeah. Student teacher ratio. Paragraph 5. Page. Oh, that page.
In a school where the enrollment in outside classes is more than 200 per day, Sir, is less than 100, this is also school wise. Then my lord kindly consider paragraph 6C, my lord, at the end of this speech, 102, paragraph 6, that becomes 12.
Yes.
Paragraph C, school's mention is point by the number of teachers and parateachers for that particular school. For upper primary classes 6 and there are at least 2 teachers in each subject, namely language science and geography. Then 7 is important. At least 50% of the kids engage mathematics. Our this entire guideline is by the school specific. What my learn is mere plain mathematics. Or is submitting that should be restricted by color. This will lead to an another small quality that you want to gather. Teacher and one scholar that is not the intention of Muller was there for it. But these are my
My lord, essentially, my lord, 2 points have been raised by the petitioner. The first point is that the order impugned in this writ petition is contrary to the order passed by my Lord Justice I.P. Mukherjee, as his lordship then was. As his lordship is still there, I'm sorry, my lord, my Lord Justice I.P. Mukherjee. And the second point is that respondent number 7, Dilruba Khatun, could not have been appointed in 2011, contrary to the GOs of 2010, because after 2010, there was a direct bar to appoint these teachers, and it was said that if a vacancy arises, it should be left vacant till a regular teacher is appointed. No more para teachers. These are the 2 points. These 2 points are there in paragraph 35 and 37 of the writ petition. And all other points center around this. Now, my lord kindly takes the order of my Lord Justice I.P. Mukherjee at page 71. Why the matter was remitted back to the authorities to decide.
Yes.
Kindly, my lord, turns over to page 72.
Yes.
After the quotation, kindly takes at page 72 immediately after the quotation. There is one gross mistake that the district project officer has committed wrong in this order. Without any reason, he has stated that the post was reserved for women. In fact, the advertisement dated 10th June 2004 inviting applications, only 50% of the vacancy was said to be reserved for women. At least he should have decided this point, because that decision was crucial for the decision in point 2 decided immediately thereafter. On the other hand, the writ petitioner has been working as parateacher from 2006 to 2011 when the decision of the project officer dated 29 June 2011 was made. So what was lacking is that the finding that why it was 50% reserved. Because Malad, this guidelines which has been placed by Mr. Mukherjee was not before Malad Justice Mukherjee, and Malad now it has been placed before Lordship, that why it is 50-50. But this reasoning was lacking in the order. So first we need to find whether this reasoning is there in this present order or not. If it is there in the present order, then it is not contrary to the order of Malad Justice Mukherjee. Now Malad kindly comes to the impugned order. My lord, Mr. Mukherjee has already placed from 102 bottom, page 102 bottom.
Yes.
A notification for engagement of para-teacher was published by the district magistrate and district project director Nodia, dated so-and-so. The resolution adopted in the meeting of district SSA, dated so-and-so, is in the following tune. In respect of engagement of para-teachers at upper primary schools, wise ratio of male and female would be 50-50. Rafiqul Alam Bishwas, Dilruba Khatun and others took part in the selection process for engagement as para-teachers at Doradaho Union High School under Korimpur News CLRC in the district of Nodia with reference to engagement notification dated so-and-so. Initially, out of total 7 number of posts, 4 posts were reserved for women candidates to maintain 50% women teacher reservation. Because of these guidelines, which Mr. Mukherjee just placed. Rafiqul Alam Bishwas was appointed as para-teacher on 31st of October 2006 after the resignation of Shushmita Mondol. Then kindly skips over a few paragraphs. Very well, I am reading it. Being aggrieved means very well. I am reading it for my learned friends' satisfaction. I can read 8 pages, 9 pages. That is not the problem. Being aggrieved, the Dilruba Khatun filed WP number so and so. The Honorable Justice Devashish Kaur Gupta passed an order or so and so directing the DPO Nodia to consider and dispose of the representation. This representation was under challenge before Justice Mukherjee. Now, Malad, kindly, Malad, if my learned friend feels these are important, he will read it again. In reply, I have no difficulty. Kindly comes to 104. Second last bullet point.
Yes.
From 2006 to 2011, the petitioner was engaged contractually for 1 year at a time. The termination of such engagement or contract, whichever is earlier, automatically cancel the engagement and no further right to continue in the said post arises therein. Engagement of Dilruba Khatun in 2001, and that too after a lapse of 4 years, in compliance of the order of the Honorable Court dated 18th December passed in so and so, and when there was a ban on any new engagement of the para-teachers of PBSSM, was irregular. For the aforesaid irregularity, the then DPO SSM appears to be prima facie responsible. Accordingly, the district magistrate and district project director, being so and so, was brought to the notice with a memo so and so. Hereby, the district magistrate and district project director is being requested to cause an inquiry and submit an action taken report. Then, Madam, kindly turns over to the next page.
Yes.
Kindly skips over one paragraph, second bullet. Further, as per extant norms under PBSSM as mentioned in memo so and so, dated so and so, which clearly states that if any para teacher engaged previously in any school leaves the job or has already left the job, or if his position falls vacant due to any other reason, the vacant position also shall not be filled up by any engagement of the para teacher so and so. Then, Malad, the other bullet points have been. You please read it in the reply. Kindly let me put my case in my way. বসো না একটু বসো না আমি বলিনি কথা কথা দুজন মিলে বললে কি করো তুমি বসো তুমি এখন বসো 2 মিনিট বসো 2 মিনিট বসো Then, Malad, there are objections at page 106.
Yes.
Then, Malad, kindly comes to. Kindly give me 1 minute, Malad.
Paragraph 7 Roman.
Yes. Kindly comes to Malad, then page 107.
Yes.
Roman 2. 107 top.
Yes.
Thereafter, the DPO, in compliance of the order of the High Court of so and so Dilruba Khatun, passed and reasoned order directing the Secretary Managing Committee Doradaho to ensure engagement of Dilruba in place of the petitioner. The DPO, in compliance of the order of the High Court that so and so, again passed and reasoned order with a memo so and so with the opinion that the post vacated as a result of resignation of Sushmita Mondol should have been reserved for women, and therefore the engagement of Rafiqul Alam Bishra in the said post was unjustified. Now, this finding is being upheld in the present impugned order. This reasoning that since it was vacated by a female teacher, it should be reserved for a female teacher, this reasoning was not there in the earlier order, which was set aside by my Lord Justice Mukherjee. Now, Malad, reading in tune with the guidelines, if it is 50-50 and one post is vacated by a female teacher, it should have been given to a female teacher, which is respondent number 7. Now, this reasoning was absent in my Lord Justice Mukherjee's order, which is there in this reasoned order sufficiently. This is the first point. Second point is that when there was a bar to appoint a para teacher, how could she have been appointed? Now, Malad, your Lordship has found that the date on which the petitioner was engaged was 31st of October 2006. Therefore, it was mistakenly done. If it was mistakenly done, and if the respondent number 7 is to be engaged now, that must relate back to the date when the petitioner was wrongly appointed. It cannot be considered to be a date of 2011. What the petitioner is arguing today, now the petitioner has been terminated. Now, if the petitioner is also terminated in 2011, what the petitioner is arguing to his detriment is that from 2011 onward, no para teacher can be engaged. Then the petitioner himself cannot be engaged. But the question is that why Dilruba's date will relate back to 2006? Because the Dilruba should have got the engagement in 2006. But wrongly it was given to the petitioner in 2006. And therefore, my lord, more or less the doctrine of restitution is to be applied by your lordship. That it was wrongly given at that point of time. Dilruba missed out for 5 years. And now Dilruba has to put back to that position where she should have been in 2006. Now, squarely, my lord, this date, if the doctrine of restitution is to be applied by your lordship, it is to be seen whether Dilruba was eligible for this appointment in 2006 or not. There is no doubt that Dilruba was eligible in 2006. If that be so, then my lord, if Dilruba is wrongly displaced in 2006, the date cannot be 2011. Whether she gets the benefit or not is a second thing. But her date should be reckoned from 2006. But in support of that, if I may place a few decisions, my lord, two decisions are on section 144 CPC, but the principles are same, my lord, and the third decision, my lord, will be paragraph double.
You are for the state.
I'm for the statement. Paragraph double.
Jahan is for the private respondent.
Private respondent.
Oh. Well, this is AIR 1961 Calcutta, page 70. Kindly take para 22.
Yes. Yes.
The next question is whether the tenant is entitled to restitution under section 144 of the CPC. Section 144 of the CPC does not say that a person would be entitled to restitution simply because the decree is set aside or varied or reversed. The condition under which the person would be entitled to restitution is that he must be on the date of application a person entitled to the benefit by way of restitution or otherwise. The section clearly says that the restitution would not come as a matter of course, either on variation or on reversal of a decree, but the person must also be entitled to any benefit by way of restitution. What I mean to say is, if a suit is instituted against a trespasser and the plaintiff gets a decree against the trespasser, and finally that the decree is reversed till the trespasser be entitled to restitution, he will not be entitled to restitution for the simple reason that he is not entitled to the benefit by restitution. So, my lord, your lordship will only have to see whether the person was eligible or not, whether the person is a trespasser or not, without any eligibility. In that case, restitution will not apply. But here, respondent number 7 was otherwise eligible. But whether 144 applies or not by the third decision, that will be clear. But for the timing, these are on civil principles. The third one is on 226, application in 226. Next, your lordship will kindly take 2024. No. Next, your lordship kindly takes AIR 1966, Supreme Court 948. Paragraph 4.
Yes. Yes.
It's a bit longish paragraph, I'll just place the relevant part. Yes, kindly takes, where paragraph, your lordship has found where paragraph 4 is starting,
Yes.
turns over to the next page, where it is internal page 3.
Yes.
At the top, page number.
Yes. Yes.
Kindly, comes to the middle lower, the principle of the doctrine of restitution. Sentence
Yes.
starting the principle of doctrine.
Yes, got it.
The principle of the doctrine of restitution is that on the reversal of a decree, the law imposes an obligation on the party to the suit who received the benefit of the erroneous decree to make restitution to the other party for what he has lost. This obligation arises automatically on the reversal or modification of the decree and necessarily carries with it the right to restitution of all that has been done under the erroneous decree. But here, in place of decree, your lordship will read that first order of DPO, the first engagement. Since the first engagement is wrong, this person has to be put into that position today. So the date cannot be 2011. Otherwise, there will be no restitution at all. She would have lost the 5 years. She would have lost the job for that erroneous decision. But ultimately, the doctrine of restitution is for administration of justice. It will apply equally to the administrative law as well as to your lordship's court. Now, my lord, this application in 226 kindly takes in a very recent decision, my lord, 2024, volume 3 SCC 563. But this applies the doctrine of restitution. Para 22, 24, and 26. But this applies the doctrine of restitution to injurious consequences arising from arbitrary and illegal administrative action. Though I am not calling my action to be illegal or arbitrary, what I am trying to say is that it was administrative mistake. It has to be corrected. Kindly text 22.
Yes.
The second step relates to restitution. This operates in a different dimension. Identification and application of appropriate remedial measures poses a significant challenge to constitutional courts. Kindly mark it, not civil courts, constitutional courts, largely attributable to the dual variables of time and limited resources. Then 24. The inherent difficulty. Next page, Malak.
Yes.
The inherent difficulty in bridging the time gap between the illegal impugned action and the restitution is certainly not rooted in the deficiencies of the law or legal jurisprudence, but rather in systematic issues inherent in the adversarial judicial process. The protracted timeline spanning from the filing of a writ petition, service of notice, filing of counters, final hearing, and then the eventual delivery of judgment, coupled with consequent appellate procedures, exacerbates delays. Then 26. It is in this reality and prevailing circumstance that we must formulate an appropriate system for preserving the rights of parties till the final determination takes place. In the alternative, we may also formulate a reasonable equivalent for restitution of the wrongful action. But in matters like this, where back and forth the parties are coming before the court, the decision relates back to 2006, but we are already in 2024. First, the petitioner comes, that why it has been given to Dilruba. Then Dilruba comes, why it has been given to petitioner. Then the court remits it back, an order is passed. They come back before the court. Court says that no, now intervention of principal secretary is required. Matter goes back to principal secretary. Then principal secretary passes this order. Now again the petitioner before the court. So in the process, my lord, 18 years are gone by. But for this delay in this justice delivery system, the person who has actually lost is to be identified. Her eligibility is to be ascertained. And she has to put back to that place. Put back to that place means 2006. Therefore, what circulars came in 2010 is immaterial. And that is why the principal secretary holds that this appointment should be given to the respondent number 7 in lieu of the appointment which was given to the petitioner. Therefore, it is inconsequential that para teachers were restricted to be appointed after 2010, which is the only other point in the writ petition. But those are the 2 points. I have gone through the entire writ petition. There are 35 and 36.
Yes, yes, Mr. Jahan, anything to add?
Yes, Lord. I do accept and adopt the submission made by Mr.
Yes, yes.
Even then, Malad, I shall
After
just
such submission, I think you have nothing to
I
add.
shall indicate 2 things that kindly come to page 66. That was the first writ petition by my client. That's the respondent number 7 in 2006 when there was no ban.
No?
There was no ban. The ban of 2010, that was not
Yes.
2006.
Yes.
And another thing, my lord, this process of selection that was initiated in 2004. Now, somehow there was some, my lord, litigation pending all over the West Bengal, and that was not completed. Since the late hour or the end of December 2005, this process was again initiated, or again, my lord, started. Now, this 2006 engagement, 2 are lady.
Okay, you are not to narrate the entire facts.
No, I'm not on that.
Anything
Who
to add?
resigned? No, who resigned?
Anything more to add?
No,
on
who
legal
resigned,
point?
my lord? Then this particular petitioner joined. So appointment of petitioner is not fresh one. What he is claiming that he...
Yes, got it.
So that would be my case before lordship.
Okay.
My honorable said that in place of Sukhmitam, that was the observation of the principal secretary. Let him show this. Where is that? If that is there, what is said last? That he is to observe that the appointment of Dilruba in place of approval of Mr. due to resignation of Sukhmitam Mondol was right. Let him show this right. I am saying that your lordship kindly pass a judgment after taking time to see everything. Well, in the order of the principal secretary, it was never stated that Dilruba appointment was right. On the other, it was said that Dilruba appointment was irregular. That should have been followed by advertisement. That is the order of the principal secretary. But he has never said that the appointment of Dilruba was right. whether it is from 2006 or 2008, later on, that he used to observe that his appointment is good. Whose appointment did you have? I'm taking this in not a sentence. It was stated that Dildubar
Okay.
appointment was right. My lord, I
Ashwin, that's all. Allow the court to pass on.
and the ratio of 20%. I have always said that he's never seen the color of the day. That was not advertised, nothing.
Okay.
The first time disclosed by the official.
Okay.
So why not first advertisement should be taken into account? And that,
Okay.
that
The petitioner, the petitioner and the private respondents are embroiled. 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 Embroiled in a protected litigation for about allow the court to pass order.
passed an order
Okay, okay.
that both of them should be accommodated. Both of them should be
Huh?
because man is there and the wife is
Only one, how can this something that can be made?
my lord, this is the order of justice. I can facts. I can get facts.
Okay, 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 allow the court. কি বললেন? Petitioner and private respondent number 7 are embroiled in a protected litigation over a period of more than 1.5 decades. For a period of over the engagement by pertaining to over the engagement of a para teacher in Doradaho Union High School. Located in the district of Nodia. Stop. The origin of the dispute which led to such long drawn litigation can be traced to a selection process initiated by the district Sarvashikha Abhijan. What is Sarvashikha? District Project Director Sarvashikha Abhijan SSA. What is the full meaning of SSA? Sarvashikha Abhijan Nodia in 2004. Stop. To further such objective, a notification dated 10th June 2004 was issued for filling up 4,000 posts of para teacher in different schools across the district. Stop. In that notice, it was specified that the 50% of those posts shall be reserved for women. Stop. At that time, neither the petitioner nor the private respondents submitted their candidature for the post.
No, that was submitted. That was
Okay,
submitted both of
stop.
us, both.
Hmm?
Because that is not the dispute. That they have submitted, incarnate.
Stop. The record reveals that there was 7 vacant posts in Doradaho Union High School. Stop. Out of which 4 posts were reserved for women, while 3 posts were reserved for male candidates. Stop. After completion of that selection process, the para-teacher was appointed in all 7 posts. Stop. Subsequently, one female para-teacher, namely Susmita Mondal, resigned from the post. Consequently, a post of para-teacher fell vacant following such resignation. This starting point of the dispute. I just stopped getting into the school. Took necessary steps to fill up the post, fell vacant due to resignation of Susmita. Stop. At that time, the petitioner and the private respondent offered their candidatures for the post. Stop. The petitioner, namely Rofikul Alam Biswas, was engaged in the post in 2006. Stop. Assailing the legality of, challenging the legality of the petitioner engagement to the post. No, stop challenging them. In the meantime, the private respondent submitted a representation before the competent authority, claiming in her engagement in that post. However, as despite receiving such representation from the private respondent, the same was left unattended. The private respondent was compelled to paper a petition being WP number 25569 within bracket W of 2006, which was disposed of by a coordinate bench of this court by an order dated 18th December 2006, directing the competent authority to consider the petitioner, and dispose of the representation presented by the private respondent in accordance with law within the time specified therein. Stop. Pursuant to that order, dated such and such 18th December 2026, the district project officer passed an order, issued a order dated 31st January 2011, which noted that the pair for engagement of the petitioner could not be considered since by an government order dated 27th March 2010, issued by the state project officer. It was আচ্ছা কি বললাম officer
No penalty.
a complete ban was imposed on such engagement on or after that date. However, the order dated 31st January 2011 noted that the allegation raised by the private respondent regarding the illegality of the engagement of the petitioner in the post would be inquired into. So, subsequently, district project officer found that the allegation raised by the private respondent was justified, and accordingly the private respondent was engaged in place of the petitioner in the post of para teacher in Doradaho school in 2011. Stop. This incident constrained the petitioner to file a writ petition being WP 11690 within bracket W of 2011. Stop. This writ petition was disposed of by a coordinate bench by an order dated 4th July 2013. The bench observed that the district project officer committed a wrong in that order, as no reason was assigned in support of its claim that the post was reserved for women. And accordingly, the issue was remitted back to the district project officer for taking final decision. And till the final decision is made, a direction was given to permit both the petitioner and the private respondent to continue to serve the school as para teacher. ঠিক আছে? Stop. However, I just stop. By an in deference to the order passed in WP number 11690 within bracket W of 2011, the district project officer passed a reason order in which it was recorded that the engagement of the petitioner, namely Rafiqul Alam Biswas, in the post fell vacant following the resignation of Susmita was erroneous, since the post was reserved for women.
77 last paragraph.
Women.
77 last paragraph.
Women.
That order, 77 last paragraph.
The order dated 11th September 2013 was assailed by the petitioner in a writ petition being WPA 4372 of 2014. Stop. Record reveals that by an order dated January 20th 2023, the issue was again delegated to the issue was then referred to the Secretary School Education Department with a direction to resolve the same by passing a reason order. Stop. The reason order passed by the Secretary in compliance with the order dated 20th January 2023 in WPA 4372 of 2024 is under challenge in this petition. Stop. Mr. Ghosh, learned advocate defending the petitioner, invites my attention to the notice and submits that the reservation, 50% reservation target was district-wise, not school-wise. Stop. Referring to the appointment letter, a letter of engagement issued in favor of the petitioner, he submits that that letter of engagement dated 28 September 2006 issued by the district project officer indicates that at the time of issuance of letter of that
Kind of recommendation.
the competent authority maintain the policy of 50% reservation for the women. Therefore, Mr. Ghosh claims that following the reservation policy district-wise, the petitioner was engaged in the post of para teacher in the school. Stop. Inviting my attention to the application submitted by the private respondent ঠিক আছে, offering her candidature for the post, Mr. Ghosh claimed that private respondent applied for the post of para teacher in Boiradaho Boiradaho Union High School. He seeks to contend that the private respondent never claimed her engagement in Doradaho Union High School. Stop. Mr. Ghosh further submits that a coordinate bench in its order dated 4th July 2013 specifically observed that the district project officer committed wrong in arriving at a conclusion that the post was reserved for women. Stop. And he submits that running contrary to this observation, the reason order under challenge of this in this petition noted that the post was reserved for women. He submits that such observation cannot be allowed to be sustained. Stop. He further submits that although the state categorically decided not to give any engagement to the post of para teacher after 2010, however, in the case at hand, the private respondent has been given engagement in the post after the cut-off date in 2011. Cut-off date in 2011. Stop. He submits that for this reason, the order under challenge in this petition is legally unsustainable, and accordingly the same is legally unsustainable, and he praised that submit that the petitioner who was lawfully appointed in the post in 2016 and 2006 and render unblemished service to the school until her 2011 until her forceful ouster from the said school in 2011. Such person cannot be deprived, taking a plea that at the time of filling the post, the authority committed a gross mistake mistake. Stop. He submits that the direction can be given to engage both the petitioner and private respondents. ঠিক আছে? আচ্ছা। In rebuttal, Mr. Raichaudhuri, learned advocate, repenting the respondent number 6, Rai Mukherjee, respondent number 6. Respondent number 6, 3, submits that a confusion has deliberately sought to be created, taking the name of the school by the petitioner, taking the name of the, sought to be created by the petitioner. ঠিক আছে? Pertaining to the name of the school. Inviting my attention to the certain portion of the order, of the reason order dated 6 April 2023, 23, he submits that the order categorically, specifically clarified that there is no school with the name Boiradaho Union High School in the same demographical area in the district of Nadia as on the date of issuance of that reason order. ঠিক আছে? He submits that the order specified that in that demographical area there is only one school, namely Doradaho Union High School. ঠিক আছে? Which situates Doradaho High School. Stop. Stop. He submits that taking me to the relevant portion of the order, of that order, he submits that the district SSA committee in its meeting, district SSA committee in its meeting dated 18th October 2004 decided that the reservation of 50%, 50% reservation for the women, would be school wise. Stop. Relying upon the guideline for engagement of additional para teacher, ঠিক আছে? Annexed to his writ petition, to the affidavit of opposition filed on behalf of respondent number 3, he submits that this guideline categorically stated that at least 50% of the teacher engaged have to be women teacher in a school. Therefore, according to Mr. Rai Mukherjee, cannot be any doubt that the reservation was directed to be maintained school-wise. He submits that the post fell vacant following the resignation of one female para-teacher in the school, and therefore the post should have inevitably reserved for female candidate, and accordingly the same should have been filled up by female candidate. However, one mistake was committed by the then competent authority to fill up the post by a male candidate, namely the petitioner. Stop. Mr. Bandyopadhyay, learned advocate representing the state, defended the order under challenge in the writ petition, saying that, contending that the order defended, contending that the petitioner challenged the said order as well as the engagement of the private respondent on two grounds. Stop. He submits that according to the petitioner, the reservation should have been maintained district-wise. Stop. And the petitioner contended that the private respondent should not have been given engagement in the post in 2011, since the state decided not to engage any further para-teacher in any school after 2010. Stop. Inviting my attention to the certain paragraphs from the reason order challenging this petition, he submits that in the meeting, the district SSA, in its meeting, resolved that the reservation shall be maintained school-wise. Stop. He reiterated the stand, school-wise. Stop. He submitted that it is admitted fact that the post fell vacant following the resignation given by one female candidate. Therefore, the post was reserved for female candidate, and there was an administrative mistake in filling up the post by a male candidate, namely petitioner. Stop. He submits that since there was a mistake and the state has addressed the same and rectified the same, he submits that although the private respondent was engaged in the post in 2011, however, following the principle of doctrine of restitution, his engagement, which relate back to the date of the petitioner engagement in 2006. Stop. He cites the decision reported in AIR 1961 Cal 70 bracket Mohadeo Prasad Sao versus Calcutta Dyeing and Cleaning Company. আচ্ছা AIR 1966 Supreme Court page 948 আচ্ছা within bracket Binayak Sai versus Ramesh Chandra Panigrahi and others. আচ্ছা সাই বানানটা হচ্ছে SWA and 2024 volume 3 SCC page 563 bracket Manoj Kumar versus Union of India and others. Stop for the proposition that the person who has suffered due to any erroneous order or mistake, that person should be given benefit of restitution and should be given benefit of restitution of this wrongful action. Stop. Mr. Jahan Lanet advocate representing the respondent number 7 adopted the submission advance on behalf of the state. Stop. Had the Lanet advocate appearing for the respective party peruse the materials on record. Stop. If the admitted fact is summarized before delving into the contour of controversy surrounding the petition, it would be evident that the post was vacant due to the resignation given by one female candidate, namely Susmita Mondal. Stop. Pursuant to the selection process which was initiated in 2004, 7 posts of para teacher was filled up by the school, out of which, following the reservation policy, the 4 posts was reserved for female candidate and 3 posts was reserved for male candidates. And the Susmita Mondal was engaged in the post reserved for female candidates. Susmita Mondal tendered her resignation in 2006, requiring the school authority to undertake another selection process to fill up the post vacated by Susmita Mondal. As noted earlier, the petitioner and the private respondent both offered their candidature for the post. Stop. After completion of that selection process, the petitioner was chosen for the post, and accordingly a letter of engagement was issued in his favor. Stop. Thereafter, as noted in the preceding paragraphs, the private respondent also claimed her engagement in that post, and such claim and rival claim led to a spat of litigation, a series of litigation in this court, requiring this court intervene into the disputes in various writ petitions presented by the petitioner and also by the private respondent. And ultimately, the issue was referred to the secretary, principal secretary, school education department for its effective resolution. Effective resolution. Stop. The principal secretary in its principal secretary passed a reason order. Stop. In that reason order, the principal secretary specifically mentioned that the district sub SSA committee in its meeting dated such and such, 18-10 such and such, then fully resolved that the reservation should be maintained school-wise. And accordingly, out of 7 posts, 4 posts were reserved for female candidates. And therefore, there cannot be any doubt. There can be no doubt in the conclusion that the post in which the petitioner was engaged in 2006 was reserved for female candidates. So if a male candidate is appointed in a post reserved for female candidate that is engaged, that engagement cannot be regarded as a valid, and therefore the reason order noted that the petitioner engagement void ab initio. I do not find any infirmity in such a decision. However, regarding other part, that is regarding engagement of the private respondent of the post, the secretary banked upon the notification issued on 27th March 2010 and 9th June 2010, and concluded that the private respondent concluded who is the and express suspicions as to whether in view of those circular the private respondent engagement can be stated to be valid. Stop. Stop. So it has been held, so it has been established that the post was reserved for women candidate. Therefore, the private respondent should have been engaged in the post in 2006. However, due to the litigation and intervention of this court, due to the administrative mistake, the said engagement could not be given at that time, which was ultimately given in 2010.
11.
11. Stop. Stop. That's it. The circular which was issued in 2010 cannot be applied in a pending action. Okay. And if the legislature or any administrative instruction intend to affect any pending action, the circular must contain the specific word, must contain such the circular must indicate
Express intention.
with express word that the legislature or the administrator intended to affect the pending action or pending selection process. In the given case, the selection process was initiated in 2006 when the circular did not came into force. Therefore, to affect that selection process, the circular is to be given retrospective effect. And the circular is not, circular does not indicate the same. এখানে আমার একটা I myself have passed a judgment. It is reported that whether that circular can be given effect to in the pending action or not. Here I shall write. Stop. For instance, for example, if any statutes, notification or government order statutes says that no suit shall be instituted, it would be construed that the legislature did not intend to affect the pending suit. But if the legislature says no degree shall be passed, that would be an indication of the intention of the legislature that legislature intended to affect the pending suit. Both those tribunals says that no engagement given to the post of para teacher after the issue of the order. That this word is not sufficient to affect the pending selection process. Therefore, I access my agreement to the contention advanced by Mr. Bandyopadhyay that this circular not affect the selection process initiated by the concerned respondent in 2006. Stopped. And although the private respondent cannot claim any benefit, either notional or actual, of his appointment from of his engagement from 2006, however, his engagement shall relate back to the date of engagement, shall relate back to the date on which the petitioner was engaged in the post. Hmm. Hmm. On which the petitioner money achieved. Stop. Therefore, I do not find any infirmity in the reason order warranting this court to interfere with the same. Accordingly, the petition is dismissed. However, no other as to the cost.
Extremely grateful.
Hmm?
Extremely grateful.
Who is circular?
Only my appointment. He never said because vanity. That's why I'm saying that.
Okay. Delving into the contour of controversy.
He's hardly from 2011. He's also
The judgment relied upon by Mr. A distributable fact. It would not be appropriate to accept to direct the school authority to engage both the petitioner and private respondent. It will result in creating a financial burden upon the state also. Okay. Next, only one matter. Oh. We are forced to hear the court. What can we do? We have to be brief. I have many matters, hearing matter. We have to brief nowadays. And reading I1 junior, I have stated. Now reading pattern is to be changed. We read the entire affair. If you read 4 words, Mr. Ghosh, are you listening to the court? Entire affair can be, entire affair can be read. Suppose one person has committed a murder of another person with knife. You read 4 words, Ram Sam, knife murder, entire affair is read. Only 4 words required. At the time of reading also we have to shorten. Otherwise, if you go on reading one repetition, thereafter entire annexure, one day one repetition. Both of them to okay, later on. Next.
Not item.
Yes.
Not item 2, number 2, my lord. I'm for the opposite party. I'm seeking a week's adjournment, my lord, to the personal grounds of the advocate on record, my lord.
Last occasion, my lord heard the matter, my lord directed me to serve up, my lord, to prepare a supplementary evidence. And in the meantime, my lord, the interim order has expired. I filed an application that is before your lord.
Reinstatement.
My lord.
No, this is 138.
This is 138, madam, my lord.
138, my lord.
No, a reinstatement of the interim order.
No, I'm not objecting to that, my lord. Kindly fix up the matter any day next week, my lord.
What is your application for reinstatement? Can 5? Hey, look at the CRAN 5. of 2025. This application has been presented for reinstatement of the interim order 27, 2077 হয়েছে? এটা কত সালের হবে? কত সালের বলুন তো? 2007, 7টাকে ইয়ে। আর লিখুন, বাই রিজন অফ এ typographical error in the cost title of the order dated three, four, so. Item number 6.
Well, at 6, I appear on behalf of the petitioner. Well, that I'm not aware as to why it has come up today.
ভালো করে দেখেন, আবার কি নাম্বার? এটা কি হয়েছে নাম্বারটা?
The matter is supposed to come up on 6th August.
এই আবার দেখুন, এটা হবে, এই আসুন, সেম রিট পিটিশন হবে So the matter has not been delivered. So are you to date the
Affidavit in reply, if any, may be filed in the meantime.
Actually, affidavit, the parties are directed to exchange their affidavit in the meantime. Next.
Item number 8. I'm appearing for the respondent, Your Lordship.
Okay. Respondent, কেউ নাম দিলে
Lordship,
দাসবাবু?
item number 8 and 9, I'm appearing for the respondent, Your Lordship.
8 and 9.
8, we are for Union of India, that is respondent number 5. And other
You are appearing for respondent number?
respondent, my lord.
In item number 8 and 9, you are appearing for respondent number? বেরিয়ে গেছে। এই দাসবাবু, কেউ যদি নাম দিতে আছে আইটেম নাম্বার 8 and 9, একজন কেউ অ্যাপিয়ার করেছিল, দিয়ে দেবেন। আমি শুনতেই পাইনি।
I appear for the petitioner with Mr. Sengupta.
Yes. Someone, most probably respondent number, he appearing through VC.
8 or respondent number 5.
Yes.
Item
Use your
number
other
10, my
side.
lord. I have filed a bail application, my lord, in connection with, my lord, the order of conviction passed by the learned subdivisional magistrate.
Where is the order of conviction
Order of conviction.
and appeal?
Kindly take up the revision, my lord. The order of conviction, my lord, the passed by the learned subdivisional magistrate, page number 9 of the revision. The petitioner was, my lord, directed to undergo imprisonment of 2 years, and the offense was 411 of the IPC. Now, my lord, as on date, the petitioner has already undergone a detention of 7 months and 12 days. Now, my lord, the petitioner, in the meantime, my lord, after the matter got dismissed for default, the petitioner, my lord, was not arrested, and subsequently this year, in the month of March, the petitioner has been arrested, and thereafter we filed an application for restoration and condonation of delay. Your lordship was pleased to condone the delay and, my lord, restored the revision. Now, my lord, in the meantime, the petitioner has already been arrested, so he had filed an application for bail in connection with that, my lord, order of conviction. Now, lord, as on date, the petitioner is in custody for 7 months and 12 days, and 83 days he was in custody during the course of trial. The petitioner, my lord, is a senior citizen, and my lord, he is also suffering from several ailments as well. He is suffering from diabetes, high blood sugar level as well, and also having eyesight issues as well. And medical documents are also annexed in my bail application. During his incarnation, my lord, he has also been taken to the hospital for, my lord, for his medical treatment. Those documents are also annexed in my application.
Yes, you.
There was recovery from the house of this petitioner, and my lord,
Recovery of which thing?
One transformer coil
electrical
component.
of the WBSCB.
Hmm.
And my lord, that was recovered during the police custody. And my lord, he was asked to produce the documents with regard to the material seized from his house. That was, he failed to produce all those documents. Thereafter, my lord, under 411, he was convicted for 2 years. Thereafter, his sentence was suspended, and he did not appear before the honorable court. That was cancelled, and the matter was dismissed for default. Thereafter, after 7 years, he was arrested in the month of March 2025. Thereafter, my lord, they filed the restoration application before your lordship, and your lordship was pleased enough to restore the application.
The petitioner as on date has already undergone a detention of 7 months.
So your conduct,
Regarding whatever, my lord, the facts of this particular case,
have you considered that your conduct?
as
Again, you will be granted bail then?
during the past 9 years, the petitioner was on bail. And during that time, the petitioner, there is nothing on record that the petitioner has absconded or he has got involved in any other offense.
That was cancelled in the year 2015. Thereafter, he was roaming. And suddenly, in the month of March 2025, he was arrested. Because that order was cancelled, that was intimated to the London court below. Thereafter, he was arrested.
The order suspending the sentence was cancelled
My lord.
by
Because
this
none
court,
appeared
by this court.
by this honorable court. Because
No.
none appeared and that was dismissed for default.
Since the matter got dismissed for default, so automatically, my lord, the earlier order has,
Was
my lord,
default.
deemed to be cancelled. Now, my lord,
Generally, at this stage, Prithpal Singh case 2020, you have to show the strong and compelling reason to get the bail.
my lord,
Principle is there.
my lord,
Because of the fact here, it is post-conviction stage. Pre-conviction stage and post-conviction stage, there is some.
kindly consider there are
The
two,
presumption of innocence is not available to you at this stage.
kindly consider there are two ingredients under 400.
Am I correct or not?
That is true.
Eh?
That is true, my
Your
lord.
standing of a person against whom a subtle allegation has been given, a case has been registered, totally different. After assessment of evidence, everything, a competent court of law hold your conviction and awarded punishment.
Your lordship, for the purpose of deciding on the merits of the case, your lordship need to call for the records of this particular case. But in the meantime, for the prima facie satisfaction of your lordship, my lord, kindly consider that there are two ingredients under section 411 for conviction. That is, my lord, dishonestly receiving or
Okay, you place the entire case. You place the entire case here and now you place the entire case. Court is here to dispose of.
but the records from the lower.
But if again bail is granted, then again
there is no allegation that I have absconded or I have left the jurisdiction of this court. Petitioner is just.
you filed any application
I filed an application, ma'am. Kindly
for
consider
suspension of sentence.
for suspension of sentence, Can 4 of 2025.
Yes, what is your?
But in this matter, my lord, there is recovery. But he could not produce any document to that effect. My lord, considering his conduct that since 2015, he did not surrender himself. He was arrested in 2025 March. So his conduct is very bad in this matter, my lord.
March, April. When you have been arrested?
I have been arrested on 11th of March.
11th of March.
This year.
Today is
1st of August. And apart from that, my lord, during the course of trial, I have already undergone a detention of 83 days. And so as on date, my lord, the total detention is 7 months and 12 days. Now, my lord, the petitioner is a senior citizen.
Asun, Can 2, Asun.
Can 4, my lord.
Can 4.
In that event, my lord, he should appear before the ICCUD every week.
My lord,
Till disposal of the criminal revisional.
Every week?
My
lord, every week is not required because the investigation.
When he purchase transformer?
lord,
When he purchase
In the year 1993, my lord, the offense is of the year 1993.
He used to purchase transformer. এটা বন্ধ করুন তো এই 11. Yes.
I observed that an application for amendment after setting aside after substitution, after setting aside of amendment, one of the respondent died due to vacancy of the application.
Oh, that matter.
That matter. So I have filed an application for substitution. 1792. I have stated in my section 5 that is due to the, I am taking this responsibility because I advised him this is not a case wherein the any application for substitution required. That has been made an avertment.
Due to wrong advice.
Yes, that is wrong advice. I should be punished for that. This is my advice. My advice. Because I have explained on earlier occasions that I have challenged the government decision orders, and in absence of any government, we have to consider whether the order was legally passed or not. Because I have raised some allegation, this order was passed by the state manager in violation of the clause of the deed as also the provision of law. So my allegation, my prayer was.
Okay, oh, at the time.
So my
today allow one.
No, I have not said I have not allowed. Yes.
No, it is not. He is saying that
not said anywhere.
Landed advocate gave wrong advice that in the petition no such step is required to be taken.
I have stated, categorically stated. Main prayer is very innocuous prayer, my lord. Main prayer is very innocuous prayer.
No, you're right. It is your right to file affidavit in opposition. I cannot snatch away that right.
My main prayer is very innocuous prayer, my lord. That my application is pending for a long days. So let them consider and after giving opportunity.
So you want to use affidavit in opposition in respect of section 5.
Okay. Because it was my objection on the basis of which this application has come up. Because he doesn't want to file any application for substitution, and there on the last occasion I took the.
Yes, now I can recall.
Yes.
Now, my lord, if your lordship desires to allow, can we record the objection and if you learn with my senior order, take the matter to the land manager to decide and to pass a order.
That is my prayer. This is my very innocuous prayer.
My objection?
Yes, my lord.
My lord, I file an affidavit, let it be recorded. Let the affidavit be on record. Thereafter, you will pass it to. So there are other civil consequences because there are other pending.
Suit.
Partition suit is pending before the court period. Therefore, there may be some advantage or therefore, my lord, I will want to go into that. What is the legal compliances I will want to follow? Your lordship now desires to allow.
Recording the objection of my learned friend, my lord. Recording the objection, my lord. Very innocuous prayer to consider my representation. It will take some time.
Record. It requires. I have an instruction to file it. That's my prayer before you. Now I'm leaving it to you.
Well, let them come with affidavit what can be.
That may be.
Yes. Mr. Dotto Lanet advocate appearing for the Mr. Dotto Lanet advocate appearing for the respondent number 3 and 4 pays for leave to file
at the time of filing writ application, it has been mentioned wrongly, subject matter relating to under group 5. But this is group 9. It should not to group 9. The order is required to be passed now.
আচ্ছা ইয়ে দেখি
গ্রুপ 5 লিখে দিয়েছে।
আচ্ছা Mr. Bhattacharya আচ্ছা has pointed out points out that that mention it on Monday. Mention it on Monday.
Take your lordship.